Contribution Act.
My ladies, my lord, yes, just before that, there were two fast balls delivered by the bench yesterday, both of which I need to respond to. First, my Lady Justice King's question, which related to section 1353 of the BSA.
Just give us a moment.
That is behind its core divider, second core bundle, divider
Yep.
C, number 5. And my lady's question...
You'll have to remind me because I have no recollection.
I certainly do. My lady's question was...
Oh, well, the difference between an amendment and a repeal.
Yes.
Got it.
My lady said, well, it says amendment in subparagraph 3, not repeal. Does that mean that we don't engage the Interpretation Act?
Yeah.
Now,
sorry, was that a fast ball?
I think it was a fast ball. But, my lady, the way I'm going to deal with that is to place that argument
Yes.
in its proper place in the rank of arguments available to me, and then I'll explain to you how far I've got in relation to the question. So if I can do that.
Certainly, take your own course.
Yeah, thank you, lady. So on the overarching question is whether section 135 applies to current proceedings. The first point is this: if the enactment is clearly intended to apply to existing proceedings, then the proviso in the Interpretation Act applies, namely unless the contrary intention appears. We say, of course, as you've heard yesterday, it's obvious in the present case that the Act was intended to apply to existing proceedings, and we referred to Kadir. The second point, section 1356 expressly deals with claims before section 135 came into force. And where such claims have been determined or settled, then, quotes, nothing in this section applies. But what it doesn't say is, nothing in this section applies to claims which are still ongoing. So that's the second point. The third point, and by reference to my learned friend's language of changing the rules of the game halfway through, we're not changing the rules of the game halfway through, because the application for permission to amend to plead a claim under the Defective Premises Act was made only after this Act, the Building Safety Act, came into force. And so one can test that this way. If we issued fresh proceedings tomorrow for a claim under the Defective Premises Act, then there could be no objection to it. The fourth point is that Section 9 has not been repealed, and so Section 16 of the Interpretation Act is not engaged. The final point, my Lady Justice King's question, and based on my learned friend's submission of implied repeal. So in other words, if amended, the word amended in Section 1353 amounts to an implied repeal, then we have not overnight been able to conclude our researches in relation to that question. However, what I would say is that with all of the other arguments that rank above it, we respectfully submit that the court isn't going to be troubled by...
I apologise if you and your juniors and your team have
ended up
doing vast amounts of research.
Not at all. It's a very interesting question. So that's section
as part of the short point of law that Mr. Williamson was obviously obliged to grapple with.
Another one, quite so. The second fast ball was from my Lord Justice Coulson, and I appear yet again to have managed to lose my note on that. But it relates to Burston Co-op, and my Lord asked in relation to paragraph 46, Burs is in the second core of divider 24. Yeah, and my Lord asked, my Lord reminded me that Miss Parkin had said in relation to the sentence, in the present case there was a present liability which arose at the latest on practical completion, and Burs had suffered measurable financial detriment before then on constructing the development in accordance with the defective design, and so on. But my learned friend had said that that was contrary to Pirelli. The answer is no, it isn't contrary to Pirelli. In Pirelli, it was decided that the building owner suffered damage when his building sustained physical damage. In co-op, there's no question of the contractor making the claim, that's Burse, having owned a building that sustained physical damage. It wasn't the owner of the building. So rather, the risk which Burse ran was that it would become liable to the employer for breach of contract. So there can be no question of when physical damage arises governing the question. And just to draw my lordship's attention, I won't go through it in any detail, but at the end of the judgment,
there's the assumed fact.
There's assumed facts, but there's also a series of extracts from the pleadings. And in each case, one sees in Burse's claims down against the subcontractors, my lord, we're looking at page 478 of the report. Annex B, Burse's pleadings of duty, breach and damage. If your lordship turns through, for example, to page 481, and on 481 down at paragraph 45.1, this being an extract from the claim against Jubb, your lordship will see in the first 6 lines, Jubb failed to do this, that and the other. This was a breach of clauses of Jubb's appointment. And then it goes on, and will in turn have placed the defendant in breach of the building contract and of clauses 4.1 and so on of the warranty. And that plea repeats right through. The other observation to make is one of timing. If your lordship turns to page 477, please. Uh, 477, paragraph 5, right in the middle of the page. Practical completion was certified on the 18th of September 1998.
Yeah.
And then over the page, bearing that date in mind, proceedings were commenced, this is paragraph 12, by co-op against Burse on the 14th of September 2010. So in other words, 4 days within the 12-year limitation period for a claiming contract.
Because the contract was under seal.
Yes.
In Burse.
So the claim against Burse was for breach of contract. Burse's claim against the subcontractors was this: your breach has placed me in breach of my contract. So now I come on to the Contribution Act.
Thank you.
And I think it would be helpful if I invited the court to have open both the Contribution Act at Court C3 and the Limitation Act,
Yep.
or just the pages that have section 10 on, really throughout, because we'll be constantly referring to those provisions. Now,
I'm so sorry. I've got the Limitation Act and I'm suddenly struggling to find the Contribution Act.
it's in the core, second bundle at C3.
There's D3 and D4.
Yeah, I've got it. I'm sorry.
C3.
Is it
C3 and C4.
I have it as C3 and C4.
Okay, sorry.
I may be wrong.
Did
No,
I
no,
say
you're right.
C,
You're right.
You're right. C3, C4. Yeah.
The other thing I'd like to do, if I may, is provide the court with a hand up. Where I hope the court won't feel characterised, if I first invite attention to the diagram on the second page of this hand-up, it always is helpful to me and has proved invaluable over the years. We are looking at the ABC triangle. A is the owners in this case, B is BDW, C is URS.
I'm surprised you don't have laminated copies that you produce for every case.
That's a very good idea. And the arrows going upwards to owners are intended to represent the words liable to. The first page of the hand-up is something I'm going to refer to a little bit later. In essence, there are all sorts of scenarios in which contribution can arise, and in scenarios 1 to 5, on the learned friend's case, everyone is entitled to recover contribution. There's no objection in principle, but in example 6, we're not. And I'm going to look at whether that is a reasonable and remotely possible conclusion on the wording of the Act. The second part, timings.
Hang on, let me just look at and see what 6 is. Yes. So the position where in a defective building remedial work is carried out and there's therefore nothing for C, is it, on your...
No, it's
nothing for A to claim.
No.
There was no claim, there was no settlement,
Yes.
Yeah.
but we did the works.
Yeah.
On the learned friend's case, example 6, well, we can't recover.
Yeah.
Yeah.
Because there's no claim, however she's defined it, which is very widely.
That's right. So, now, timings I'll come back to. This arises out of the... Contribution Act is very difficult. It arises at an abstract level and partly performs an abstract function. And it's its machinery for doing so, which is quite elliptically drafted, and this gives rise to difficulties. But we will find our way through. The reason for putting timings in is to draw the distinction between when one can claim contribution, when the question of are B and C liable to A, at what point in time is that determined? When are you then entitled to an order for contribution? And then 4, when is your claim in contribution barred by limitation? And those questions are all distinct. And I'll explain when in each case those arise. So first of all, can we start please with the Civil Liability Contribution Act? Subsection 1. Subject to the following provisions of this section, any person liable, that is B, any person liable in respect of any damage suffered by another person, that is A, may recover contribution from any other person liable in respect of the same damage. That other person is C. We will immediately see that there is no reference here to the need for any claim or any settlement or any judgment or anything of that sort.
Yeah, it's just liable and same damage.
My lady, yes. Now let's come on to subsection 2, if we may. And subsection 2 and 3 correspond with one another. Subsection 2 is concerned with B and his right to recover contribution. Subsection 3 is concerned with C and his liability to make contribution. So, in 2, a person, brackets B, shall be entitled to recover contribution by virtue of subsection 1, pausing there, as if it weren't obvious already by subsection 1 that that is the origin and the fountain of the entitlement to contribution. It's made clear in these subsections. So a person shall be entitled to recover contribution by virtue of subsection 1(1) above, notwithstanding that he has ceased to be liable in respect of the damage in question since the time when the damage occurred, provided that he was so liable immediately before he made or was ordered or agreed to make the payment in respect of which the contribution is sought. Now, there are a number of points to make about this subsection.
One of which is or agreed.
Yes. Made, ordered, or agreed. I'm coming on to that. Before we get there, this subsections 2 and 3 are what I would describe as defence busters. They're not intended to cut down or modify the right which arises under subsection 1.1. What they do instead is anticipate defences that may be run by C and tackle them. And that point is made, well, I may respectfully say so, by His Honour Judge Havery in a case which is in the core bundle, first core bundle at the back, divider 21. I'm going here now, but I will come back to this case because it's quite important. Could I invite the court to look at paragraph 15? I'll come on to the facts when I next visit this case. And within paragraph 15, I'm just picking up this observation 4 lines down. The primary provision giving rise to the right to claim contribution is section 1.1 of the 1978 Act. There is no suggestion there of any limit or restriction on the right of a person to claim contribution from another person liable in respect of the same damage. Subsections 2 to 4 of section 1 are designed not to restrict the right, but to remove restrictions or defences that might otherwise be raised. Now, there is a further complexity with subsection 2, which is that what liable means in this context is liable subject to limitation. And what subsection 2 is doing is it's saying no matter that the putative claim by A against B is time barred by the time you bring your claiming contribution, provided it was not time barred when you made or were ordered or agreed to make the payment. Now, I know it says cease to be liable, but I'm referring to limitation because I anticipate that this is a concession on our part because we have accepted that prior to the coming into force of the Building Safety Act, we wouldn't have had a claim in contribution because of the operation of subsection 2.1.1.2. But that then may give rise to the question, well, hang on a minute, Mr. Harvey, is it, if you're liable, if you were liable for the purposes of the statute, surely it doesn't matter that the limitation period has passed. And this is another idiosyncrasy of this Act, because cease to be liable for the purposes of subsection 2 does include ceasing to be liable by virtue of limitation. Now, it's a concession on our part. I have further submissions on that which I can develop. If the court would like to understand that more fully, I can certainly do it. And it is a tricky point. But the learned friend doesn't dispute it, and we have accepted it for the purposes of our claim.
I'm not quite sure what I'm supposed to be not disputing.
Well, you're not disputing that prior to the coming into the force of section 135 of the Building Safety Act, I wouldn't have had a claim under contribution.
No, that's what you said.
That's what we said.
Yes, that was your concession before.
And there's
the
no
Deputy Judge.
there's no difficulty with that, and you're not suggesting otherwise. So,
So you say you can cease to be liable as a result of the operation of limitation.
In this Act.
So
Yeah.
set aside what we were told earlier in the week.
Yes,
about
exactly. Yes.
it doesn't affect liability to only it's a procedural matter to be taken by the defence.
Yes.
When we're looking at this section of this Act, it's agreed between both of you, and presumably those behind you, that it can act the opposite way around.
Now, if I can elaborate on that further.
No, please don't.
Okay.
You've grasped it.
Perhaps just one point. Imagine in a claim where A, B and C are all in the action together.
Yes.
If B succeeds in a time bar defence against A, then for these purposes he won't be liable to A. And you can test it by these means. There'll be no judgment against B to which a contribution could attach. So that's why necessarily it must be the position. And also IMI and Delta, a case called IMI and Delta, wouldn't have been, Court of Appeal, that whole case would not have been debated if liable did not include limitation. So
No, that's helpful, thank you.
that's that. Thank you. Now, the next point, of course, in Section 2 is reference to made or was ordered or agreed to make the payment. Now, ordered is fine, that's a judgment. Agreed to make is fine because that's a settlement. But it also includes just made. And that's a key point to hold in one's mind as one goes forward in my submission. The mischief that subsection 1.2 was addressing was the case of George Wimpey, in which case what happened there was that A had previously sued C, and C had succeeded on a time bar defence. So that when A succeeded against B, and then B brought contribution proceedings against C, they said, the Court of Appeal said, well, that we can't help you because you've been held not liable already by virtue of the limitation defence. So this subclause was designed to undo that injustice, because provided you were liable at the point in time of the payment being made, it didn't matter that you since became time barred, you're still entitled to bring the claiming contribution. And subsection 3 operates the other way in relation to C. A person shall be liable to make contribution by virtue of subsection 1 above, notwithstanding that he has ceased to be liable in respect of the damage in question. That's liable to A, of course, since the time when the damage occurred, unless he ceased to be liable by virtue of the expiry of a period of limitation or prescription which extinguished the right on which the claim against him in respect of the damage was based. And there we're into more orthodox territory, so that when B brings a claiming contribution against C, it doesn't matter that the notional claim by A against C would have been time barred, because the Limitation Act is procedural and doesn't extinguish the right.
That's odd, because you're saying, first of all, there are express words about limitation in 3, but not in 2. And in 3, you're saying it operates as a time bar. And in 2, you're saying we should assume that it operates substantively, although it's not mentioned.
Well, yes, this is a difficult act. But what I say is logical. If we go back to section 1.2, if there's no judgment in that example for a claiming contribution to attach to, how can you have a claiming contribution? So that's why section 1.2 must be interpreted in that way.
Also, you have to look at 1.2. You have to look at the words of 1.2. Shall be entitled to recover contribution, notwithstanding that he has ceased to be liable in respect of the damage in question since the time when.
Yeah.
So time is obviously at the heart of it.
Yes, it is. I'm going to come on to look at time.
Oh, right. Okay.
Okay, now then 4 operates, excuse me, and again this is quite complicated, but 4 operates as an exception to 2. So 4 again is applying to B, the party who is claiming contribution. A person, now of course this isn't going to be dealing with ordered, because this is not the subsection that's dealing with any judgment, because it's dealing with settlement. So 4, a person who has made or agreed to make any payment excuse me, in bona fide settlement or compromise of any claim made against him by A, shall be entitled to recover contribution in accordance with this section, without regard to whether or not he himself is or ever was liable in respect of the damage, provided, however, that he would have been liable, assuming that the factual basis of the claim against him could be established. Now, what that means is, if B has settled with C, then there is a limit to what B needs to prove in his claim over against C. All he has to prove is that he would have been liable, assuming that the factual basis of the claim against him could be established. And this clause is what the case of IMI against Delta was concerned with, which I can come on and look at a bit later. But the upshot was this. In a much earlier decision of Mr. Justice Coleman, called Hashim, it was determined that in answering the question, would you have been liable assuming that the factual basis of the claim against you could be established, included the need to take into account collateral defences. Those included limitation defences. That was the way the law stood until IMI and Delta. What happened in IMI and Delta, in Sir Colin Rymer's judgment, was that he said that Mr. Justice Coleman had allowed the tail to wag the dog, and that it wasn't so. The situation is that defences such as limitation are no longer available by operation of Section 1.4, so that it's no answer for C to say to B, you shouldn't have settled because the claim against you was time-bound. And that's the ratio of IMI and Delta. Now, I'll elaborate a little later, but moving on to subsection 6, please. This applies both to B and C.
Just give me a second. Yes, sorry.
Subsection
1.6.
Yes, subsection 6 applies to B and C. And it says this: references in this section to a person's liability in respect of any damage, so for example in subsection 1, are references to any such liability which has been or could be established in an action brought against him in England and Wales. So what that makes clear is that A needn't bring a claim against B or C, and provided that the liability could be established in a claim, well then that's sufficient. So subsection 1.6 drives straight through Malone and Friends submissions in relation to what she called held liable. You either have to be held liable or have entered a settlement. And then finally, before we look at the Limitation Act, can we look at section 6.1? That there's another subclause dealing with, subsection dealing with liable, and what liable means. And it's at 6.1, which says, a person is liable in respect of any damage for the purposes of this Act if the person
I'm very sorry.
I'm terribly sorry.
Have you gone...
You mentioned the Limitation Act, but you didn't mean that. You meant the Act which were in the Contribution
I'm
Act,
terribly
Section
sorry,
6.
Sorry, no.
Just before coming in.
I was listening anyway.
6.1. 6.1, another subsection dealing with liable. A person is liable in respect of any damage for the purpose of this Act if the person who suffered it is entitled to recover compensation from him in respect of that damage. So neither that subsection nor subsection 1.6 nor subsection 1.1 makes any reference to the need, A, for there to be any proceedings or any claim or any intimation of a claim, and indeed quite the opposite. They say that provided liability could be established, that's enough. Now, just to elaborate a little bit, as I have said, subsection 1.2 was enacted specifically so as to reverse the injustice caused by George Wimpey. The reference for that is a single paragraph in Co-op v Taylor Young in the Court of Appeal. I'm happy to go to these, but I can give references.
No.
So in Co-op v Taylor Young, I'm terribly sorry. Subsection 1.3, forgive me, was enacted to deal with the injustice in George Wimpey. Subsection 1.3, that's Co-op v Taylor Young. That's in Authority D6, out of paragraph 27. And subsection 1.4 was enacted to overcome the difficulty identified in a case called Stott. What happened there was B settled with A, but in his contribution claim, B against C, Lord Denning in the Court of Appeal said, well, you've still got to prove that you were liable. So you've still got to prove that you would have, the claim, effectively A's claim against you, you must prove in your contribution proceedings. Subsection 1.4 undoes that, and that is described and acknowledged in IMI, which is D13, at paragraph 19.
And I missed the reference to Co-op and Taylor Young is...
Co-op and Taylor Young in the Court of Appeal is D6 at 27. These are all just single paragraphs.
And it was IMI at paragraph
19.
19. Thank you.
So that traces the history
Yes.
of two of what you say are the defence busters, 1.3 and 1.4.
Yes.
Is there a link to 1.2 overturning?
No, I'm not aware of I'm not aware of an express case being defence busted in relation to 1.2.
No. But in relation to that, as a matter of generality, you rely on what Judge Havery said.
Yeah. Well, yes. Yeah. And then finally, just in relation to subsection 1.6, that was correcting another difficulty caused by George Wimpey, and that again is dealt with in Co-op D6 22 to 26. And I think I am going to go to that actually at this point because there's a very useful approach by the Court of Appeal in relation to how to approach the various twists and turns of the Act. So we are behind D6. Now, behind D6 we have the first instance decision of His Honour Judge Wilcox, and the Court of Appeal begins at page 29 behind this divider. And since we're here, I'm terribly sorry, I ought to pick up the changes that were made. So paragraph 23 at page 35 of the report.
Page 35.
Of the report, yeah. Deals with the George Wimpey case. And then in paragraph 26, the court, Lord Justice Brooke, what he does is he takes the text of subsection 1 of the Act and inserts, or as it were, read together the text of subsection 1.6 of the Act, and it's a very valuable approach. And what that then reads as is quoted by him underneath, subject to the following provisions of this section. So this is how section 1.1 would look. Any person whose liability in respect of any damage has been or could be established in an action by or on behalf of the person who suffered the damage may recover damage from any other person whose liability in respect of the same damage has been or could be established in an action brought against him in England and Wales. And although convoluted, respectfully, we say that's a very helpful way of approaching it. Now, so far as the Limitation Act is concerned, there's only really one thing that I want to point out at this stage before getting on with my submissions, and that is to draw your attention to subsection 1.2 of the Contribution Act and the language in subsection 10.4 of the Limitation Act. So you'll recall that in the Contribution Act, subsection 2, I drew attention to the words before he made or was ordered or agreed to make the payment. Now, when you look at section 10 of the Limitation Act, you'll recall the introductory wording, when did the right accrue, and then the relevant date is described in subsection 2, and that says, well, you'll find out what that is in subsections 3 and 4. Now, in 3 is straightforward, because it refers to a judgment or award. So that's the relevant date of accrual, if that's what's happened in your situation. But now subsection 4, if in any case not within subsection 3, excuse me, the person in question makes, so there's that again, or agrees to make any payment to one or more persons, compensation for that damage, the relevant date should be the earliest date on which the amount to be paid is agreed between him and the person to whom the payment is being made. Now, the court can no doubt by now see the difficulty. There is a date provided for where what has happened is that there is an agreement. There doesn't appear to be a date provided for in circumstances where the payment has been made, but there isn't an agreement. Now, I'll make my submissions on that in due course when I get to the appropriate point. But we, just so that you have the point in mind, whatever the Limitation Act may or may not provide, can't cut down or alter the rights granted by the substantive statute, the Civil Liability Contribution Act. So that's part one. That's, as it were, an introduction in relation to my submissions and looking at the clauses. Part two is another topic, accrual. Now, this breaks down into four parts, as I've put in my hand-up in paragraph 2. When can one claim contribution? When does one determine liability? When is one entitled to an order for contribution? And when is a claim for contribution barred by limitation? Now, we need to start, if we may, with Kazakhstan. And I think my learned...
I'm sorry, you said accrual, so we're under 2.
Yeah, this is part 2 of my submission, yes. So we're certainly making progress. Now, my learned friend took you to Kazakhstan in the main bundle of authorities, and I'll do the same. It's in section D, and it's behind divider 11. Now, in this case, the claimants were a group of companies, and they sued Ds 1, 2 and 3. D was the chairman, 2 was the CEO, and D3 was the financial director. There was a claim for fraud. The claim for fraud was settled, and D2 and D3, the CEO and the financial director, sought to bring contribution claims against the chairman. And they sought, as part of that, a freezing order. Now, the difficulty which Mr. Justice Leggett, as he then was, had with that claim was that, well, it's best described by him himself at paragraph 38. Accordingly, the draft contribution notice suffers from the flaw, one could well imagine it, that it does not advance a factual case of fraud or other wrongdoing by Mr. Zunas. It is necessary for D2 and D3 to advance such a case if they wish to claim contribution from Mr. Zunas, because no such case is being advanced by the claimants, which D2 and D3 can adopt as an alternative to their primary position, which is, of course, that they were not liable for fraud. The claim for contribution, which D2 and D3 are applying for permission to make, is therefore bound to fail. So the hurdle was that all the claims in fraud were being made by the claimant, and the case against the claimant's case had settled, gone. So how on earth are you? What are the claims that you're relying on? So that was the determination, and so therefore there was no question of there being a freezing order. So then the judge looks at the question of he turns to the question of cause of action. As we know, of course, if you want to have an injunction, you have to have an underlying cause of action, and he examines that at paragraph 54 through to 58. He says those cases are ripe for reconsideration. Nevertheless, they haven't been overruled. As the law stands, this court may not grant a freezing injunction unless the plaintiff has an accrued cause of action. So the question becomes, on a claim under the Contribution Act, when does the claimant's cause of action accrue? Now, that, it turns out, is quite a complicated question, and Mr. Justice Leggett deals with it, excuse me, at paragraphs 59 to 66. But one has to bear in mind that what he's dealing with is a state of affairs concerned with an application for a freezing injunction. Now, two sets of submissions were made. D1 said a cause of action only accrues when a party is held liable, and Mr. Justice Leggett did not accept that. D2 said that the Contribution Act creates a cause of action in its own right, the ambit of which is to be discerned from its terms. And this is a very important passage, which is important to understand, if I may. Mr. McGrath submitted the elements of the cause... I'm sorry, I'm at 62, lady.
Thank you.
Mr. McGrath submitted that the elements of the cause of action to be found in Section 1.1 of the Act, read together with Section 1.6, the combined effect of these provisions is that a person whose liability has been or could be established in an action brought against him in England and Wales by a claimant who has suffered damage is entitled to recover contribution from any other person whose liability in respect of the same damage has been or could be established in such an action. Mr. McGrath submitted that this test is met, and D2 therefore has a statutory right to recover. And I emphasise in both cases the language of recover, as distinct from claim. I'm not persuaded by either of these arguments. Taking D2 first, I think it is clear that Section 1.6 of the Contribution Act is concerned with the definitional question of what counts as a liability. And that's right, for the purposes of a contribution claim, and not with the time at which a right to recover contribution arises. And again, he says recover. In Cooperative, the Court of Appeal did not take issue with that analysis, but disagreed with the view of Mr. Justice Hobhouse on the further question of the time at which the test of liability specified in Section 1.6 has to be satisfied, the time at which that has to be satisfied. Mr. Justice Hobhouse had thought that the relevant time was when the damage occurred. In Co-op, the Court of Appeal rejected that view and decided the relevant time is when the contribution is being sought, and that's at trial, a decision affirmed by the House of Lords. That decision does not, however, address the question of when a person is entitled to seek contribution. It then looks at subsection 10 of the Limitation Act, and says that does address the question, but only for the special purposes of limitation. So it still doesn't answer the question of when does the right to claim contribution arise. And then over the page at 65, it is, I think, a mistake to suppose that the question, when does a cause of action accrue, is one which has a single established meaning. Its meaning may vary depending on the context and the purpose for which the question is being asked. The question is capable of meaning, when is a person entitled to commence proceedings, claiming the relief? When does time begin to run for the purpose of claiming the relief? And when does a right to be granted the relief arise? And it's reflecting that approach why I've divided those points in time into the four stages which I have. And he points out in the last sentence of that paragraph, where the claim is for contribution, those 3 dates may diverge. And then he gives an example in paragraph 66. Now, so far as a freezing injunction is concerned, the judge concluded at paragraph 75 that once the right to make a claim for contribution under CPR Part 20 has arisen, the cause of action in the relevant sense, in other words, the right to claim it, has accrued, and there's nothing to inhibit the court from granting a freezing injunction in an appropriate case. But bear in mind that in this case, the judge had decided that they could never recover contribution because they didn't have the necessary ammunition, as it were, as they hadn't pleaded any case that they were fraudulent and therefore they needed to be able to claim contribution. So he was dealing here with when the claim would otherwise, the right to claim would otherwise have arisen. Now, can I just try and summarise then what the effect of this decision is? First of all, the court did not accept that Section 10 of the Limitation Act determined when the cause of action accrued.
And when you say the cause of action, you mean the right to make a claim for
The right to make a
contribution?
claim, correct. Secondly, although the case of Co-op determined that the time when the test of liability had to be satisfied in order to recover contribution was at trial, that doesn't help on the question of when you can claim contribution. And in effect, and in relation to what was required for the freezing injunction, he determined that there's a cause of action in the sense required to seek an injunction when there's a right to start proceedings. Now, all of that may sound complicated, but I would hope now to be able to boil it down into the 4 clear propositions in relation to the 4 questions that I've asked. So, from first principles, and respectfully we say it's obvious, a party is entitled to claim a contribution when it can plead that the 3 factors in subsection 1.1 are present. That is to say that B's liability to A, the damage, could be established in an action. C's liability, likewise. And where the damage is the same damage. And we have pleaded those ingredients in the amendments, and therefore we have a right to claim contribution. And there ought to be no mystery about that. Of course, one can claim a contribution, assuming one can plead the 3 ingredients. It's common sense. And my learned friend placed some considerable reliance on the fact that in Kazakhstan, the judgment of Mr. Justice Leggett referred to the right emerging, I think, by virtue of CPR Part 20. But, my ladies and my lord, that can't possibly be right. The entitlement to claim contribution is a function of the Act which grants the right to contribution. Once you can plead your case, you're entitled to claim a contribution. you don't have to do it under Part 20. You can claim under the primary claim form, make a claim for contribution. So I'm afraid that there's no magic in Part 20. The Contribution Act confers the right, not the CPR. And there's just one further authority to go to in this context to make sure, and that's Aer Lingus. That's in the second core bundle. No, it's not. It's in the first core bundle, but divider 20. And this is Lord Justice Riggs. And may I invite the court to turn to page 1175, which is, I think, the paragraph 5 of the judgment of Lord Justice Riggs. Now, the actual issue on the appeal is at paragraph 2. It's namely whether the judgment spoken of by the statute, that's the Limitation Act, is a judgment on liability only, the damages to be assessed, or whether a judgment on quantum as well as liability is required to start time money. The answer was it's the latter. But what's of interest in this judgment is his examination of contribution at a much higher level. Paragraph 5, the 1978 Act provides for the essence of contribution, really emphasise those words, in the following terms, and then he sets out subsection 1. He also sets out section 2.1, which is the part of the Act which deals with the assessment on a just and equitable basis. 6. Thus, the liability to contribute proceeds by reference to the fact that two persons are each liable in respect of the same damage, which does not mean the same damage. As Lord Bingham of Cornhill said in Royal Brompton, Para 6, when any claim for contribution falls to be decided, the following questions, in my opinion, arise. What damage has A suffered? Is B liable to A in respect of that damage? Is C also liable to A in respect of that damage, or something? 7. It may be observed that provided the liability is in respect of the same damage, the liability to contribute appears to arise at the same time as the primary liability to the person who has suffered the damage. As often happens, the same action incorporates both a primary claim by A against defendants B and C and a contribution claim between B and C. For these purposes, it's not necessary for the quantum of A's claim to be established before the court can assess the quantum of contribution. That can be assessed on percentages. Then the judge refers to section 10 of the Act, and at paragraph 10 on the foot of the page, he says the following matters may be noted about section 10. First, the references to any damage in subsections 1 and 2 and to that damage in subsections 3 and 4 must be referenced to the same concept of damage found in section 1 of the Act. Secondly, and this is important, although the 2-year period is set to run from the date on which a right to recover contribution accrues, it's difficult to think in the absence of contrary authority that the expression is intended to convey that the cause of action for a contribution only arises at the time of any judgment, award or payment or agreement to pay, for otherwise a defendant could not claim contribution from another defendant, or at best could only do so contingently, until his own liability, and perhaps the quantum of it too, had been established, or the payment or agreement to pay had been made. Moreover, the 78...
I'll just read that sentence again. Yes. So that was an answer to the submission made by counsel for D2 in Kazakhstan. You said that section, effectively that section 10 of the limitation was the complete answer. He's saying no, cause of action, it's difficult, what does he say, it's difficult to think that expression is intended to convey the cause of action only arises.
Yeah. So in other words, under this Act, the concepts of right to claim, cause of action, accrual, so on and so forth, are rather difficult.
Yeah.
Moreover, the 78 Act, which creates the right to contribution, is written in terms of the mere occurrence or concurrence of liability in respect of the same damage. Well, it certainly is. There is no apparent need for that liability to have been established. Indeed, there isn't. That's what Subsection 1(6) says. And he goes on the contrary, Section 1 of the 78 Act makes clear a person may be entitled to contribution even when he has ceased to be liable. Subsection 3, or following a bona fide settlement, whether or not he ever was liable. Subsection 4. The difference between the 78 Act's person liable and the 80 Act held liable, or makes or agrees to make any payment, would seem to be clear and deliberate. If the cause of action for a contribution only arose after judgment, award, or payment made or agreed, then a defendant could never claim contribution of a co-defendant or another party joined by him to the claimant's action at any earlier stage. But that is something which happens all the time. So, in some respects, these are arcane difficulties, but when one steps back and remembers how procedure operates, they're all very straightforward. Of course you can claim contribution once you complete it. So that's commencement. Liability. What I mean by liability is my second question on the handout. What I mean by liability is B and C's liability to A. When is that, at what point in time is that determined? The answer to that is that it's determined at trial. And in support of that submission, we need to go back to Co-op and Taylor-Young. That's in D6. At paragraphs 22 to 28. I'll take this at a bit of speed because, my ladies, my lord, in the end, what happens is that the court says that it agrees with Mr. Bartlett's submissions. So what I need to do is go through the court's recording of those submissions, and if we start at perhaps I can start at 39.
This is in the Court of Appeal.
In the Court of Appeal, so it's page 39, well, 39 of pagination, 39.
Yeah.
He urged us, however, not to interpret Mr. Justice Hobhouse's remarks in a sense that would be inconsistent with the terms of the 78 Act. For paragraph 41st, his arguments ran along the following lines. Okay. 41st, section 1.1 refers to recovering contribution from a person liable in respect of the same damage. This expression naturally refers to liability to the injured party as seen at the time when contribution is being sought. And again, that's at trial. You might have added this for the interpretation tested by Sir John May. Right. 41. Next, he said that section 1.6 confirms its construction. It refers to liability which has been or could be established in an action. He says that the question the judge must ask himself at the time when contribution is being sought is this: has liability to the injured party been established, or could it be established? The question is not, excuse me, could it have been established? He argued that the existence in terms of subsection 1.3, it may be worth just having that open, also confirm this interpretation. If the judge had to ask himself, was there liability at the time when the damage was suffered by the injured party, this subsection would be superfluous. Because if this was the relevant question, it would be irrelevant that liability has ceased until that time. He went on to submit that the last part of subsection 1.3 is similarly concerned with the position at the time when contribution is being sought. The judge must ask himself at that time, and not in relation to any earlier time, has the person from whom contribution is sought acquired a prescriptive right which prevents liability being established by the person who suffered the damage. 44. Mr. Bartlett said that it was only under the first part of section 1.3 that exceptionally the court was directed to look at the position at an earlier date than the time when contribution was being sought. He said that this subsection was included because what he called the foundational principle that there can only be contribution where the third party is liable to the claimant does not provide an answer to the question whether the principle does or does not apply where the claimant cannot himself recover for some procedural reason, such as the expiry of an ordinary limitation period or the dismissal of his claim for want of prosecution. Subsection 3 provides the answer that in such cases the third party is to be treated as liable within the meaning of subsection 1, notwithstanding that he has ceased to be liable since the time when the damage occurred, unless covered by the second part of the subsection. 45, I accept these submissions. And if we can turn on, please, to Divider 7, the House of Lords. And please turn through to paragraphs 57 to 59. Paragraph 57, Lord Justice Brooke accepted Wimpey's and Hall's argument, that's to say Mr. Bartlett's argument, that Mr. Justice Hobhouse remarks in the Benati No. 2 were inconsistent with the terms of the 78 Act and with the decision in Oxford University. He did so for reasons which I too find compelling. And then his lordship effectively goes through the language of the Act and the sort of points that were already being made by Mr. Bartlett. But at 59, Lord Hope adds some points of his own. And it's the first of those points that we're interested in. The long title to the Act states that it is an Act to make new provision for contribution between persons who are jointly or severally, or both jointly and severally liable for the same damage. So he says that the use of the present tense fits in well with the indications which are found in the language, so that, in conclusion, when is the liability determined? The answer is it is determined when contribution is sought, and that is at trial. So the third question is entitlement. This one is much more straightforward. When is one entitled to an order for contribution? Well, of course, the answer to that, matter of first principles, one is entitled to it when one has proved the ingredients in subsection 1.1 of the 78 Act. So the last question in this four-part division is, okay, well, when does limitation expire for a claim in contribution? We've looked at Section 10 of the Limitation Act. Could I invite the court to have Section 10 to hand? And then there are one or two cases to look at which examine the question of when, in the sense of the Limitation Act, the cause of action accrues for the purposes of beginning time running. And the first case is Baker and Davis, Bundle D, Divider 10. I may have made a blunder. This case is also in the core, and I think we may have looked at it previously in the core. So forgive me, if the core wishes to be consistent, it's the core bundle Divider 21. I'm so sorry.
It's the last case in the first file.
That's right.
Because this is Judge Haven.
Yes, I don't want the court to be marked in two sets. Now, this is a very important case for the purposes of our submissions. What happened here is that the party in the position of B settled with A by agreeing to carry out remedial works. And he then did was to claim contribution from C as regards his expenditure on the remedial works. So, and I started paragraph 3. In January 97, cracking began to appear at Orchid Court. February, the claimant arranged for monitoring. In October, the defendant advised the cracking was slight. The employer was not satisfied. After much correspondence, the claimant appointed an independent engineer. In June 2000, over the page on page 51, that engineer produced a report recommending underpinning. The claimant agreed with the employer that that work should be done. It was done by contractors, instructed and paid by the claimant. The claimant also paid the employer some money in respect of losses suffered by the employer, including claims made by tenants. The claimant claims from defendant a contribution or indemnity under the 78 Act in respect of the monies expended by the claimant, having the underpinning works carried out at no expense to the employer, and in respect of monies it also paid the employer. It's common ground that the works of repair and the payment made were the subject of a settlement agreement between the employer and the claimant. The dates and terms are in issue. Now, the second preliminary issue, which you see at paragraph 6.2, does or did the settlement agreement give rise to a claim for contribution under the 1978 Act? And then the third question, when did time start to run? So the second preliminary issue, paragraph 9, please. As to the second preliminary issue, Mr. Chapman submitted that the right to recover contribution arises only where the person seeking contribution has made or been ordered or agreed to make payment of a monetary sum to the person who has suffered damage. Where or insofar as the person seeking compensation has made reparation in some other way, specifically by carrying out works at his own expense, he has no entitlement under the Civil Liability Contribution Act to recover contribution. Mr. Chapman relied on the use of the words payment in subsections 2 and 4 of section 1 of the Act. That is indeed the word that's used. In further support of the above proposition, Mr. Chapman submitted that the right to recover arises only in the circumstances mentioned in the subsections 3 and 4 of section 10 of the Limitation Act. Otherwise, there could be a right to contribution which would not be the subject of accrual under section 10.1, and there would be no limitation period. That is an echo of the submission made by my learned friends in relation to the facts which we find ourselves in. It could not have been the intention of the legislator. He submitted that there should be circumstances in which there is no limitation period. There's no question of subsection 3 of section 10 applying. I'm concerned only with 4. Mr. Chapman submitted that apart from the comparatively small monetary sum, the settlement agreement was not an agreement to make payment by way of compensation. It was an agreement to carry out work. Moreover, though it's true that payment was agreed to be made between the claimants and contractors, no amount to be paid by the claimants was agreed between the claimants and any person to whom payment was made. Mr. Chapman submitted, and I accept, that the expression at the end of subsection 4, the person to whom the payment is to be made, must refer to a person receiving the payment by way of compensation. And then Mr. Chapman relied on a decision of His Honour Judge Hicks on an article, and then he was asked whether the Law Commission shed any light. Then the judge says this, paragraph 15, which you already looked at in part. Mr. Chapman's submissions were cogent, but I reject them. They lead to a conclusion as to the intention of Parliament, which in my judgment is not borne out by the legislation as a whole. That intention could readily have been stated expressly if it existed, and I see no reason for it. The primary provision giving rise to the right to claim contribution is section 1.1 of the 78 Act. There's no suggestion there of any limit or restriction the right of a person to claim contribution from another person liable in respect of the same damage. Subsections 2 to 4 are designed not to restrict the right but to remove restrictions. Section 10 of the Limitation Act, albeit that it arises out of an enactment of the 78 Act, is directed to limitation and not to narrowing the nature of the right to contribution. The word payment in ordinary parlance is capable of including a payment in kind, as that well-known expression exemplifies. It talks, for example, of paying a debt to society by the forms of community services. In my judgment, the word payment in these statutory provisions includes a payment in kind, at any rate where the payment in kind is capable of valuation in monetary terms. In such a case, the amount to be paid by him in section 10.4, the Limitation Act, refers not to the amount of the work, but to its value. That construction, in my judgment, best gives effect to what appears to me to be the intention of Parliament. Now, this case is on all fours with our case, except for the fact that there is no settlement agreement. Why, we ask rhetorically, should we not be entitled to claim contribution merely because of the absence of a settlement agreement? Can it really be said that if we did enter into a settlement agreement tomorrow, we would be entitled to contribution? But standing here today, we're not. Of course not. That would be absurd and would upturn Parliament's intention. Now, just so that you're aware of the other cases that deal with the question of accrual for Section 10, I don't need to go to them all. In Aer Lingus at D9, the court said a judgment for damages to be assessed doesn't start time running. Instead, it has to be the judgment determining the damages. In Gillette, which is D14, agreement or payment of an interim payment doesn't start time running. It is only agreement of the final sum. And then I think we'll just turn up one case, which is Carter, which is in...
These are cases concerned with Section 10 of the Limitation Act.
Yes.
When the 2-year period starts to run.
Yes.
Not the accrual of the cause of action.
No.
But when the 2-year period starts to run.
Absolutely right.
Yep.
And can we look at Carter, which is the second core bundle of authorities behind divider 27. Now, the short point in this case, which we can see from the head note, is this. The parties had expressly conducted their negotiations which led to settlement on a without prejudice subject to contract basis, on a subject, so that the question was, well, when was agreement reached for the purposes of subsection 10? And the answer was not until you signed it, because you negotiated subject to contract. So that's what it decides, which is not of relevance to us, but there are some useful passages in the judgment which I just wish to draw your attention to quickly, if I may. And we're looking at paragraph 20, which is on page 4602. This is a decision of Mr. Pepperell, QC as he then was, sitting in the TCC.
That was paragraph
20.
Thank you.
So he introduces the topic. Before turning to this question, necessary first to consider the structure and general operation of Section 10. As noted above, time for the bringing of contribution claim runs from the date of judgment or award under Section 10.3. 20.2 cases not in 10.3 fall under 10.4. Accordingly, foot of that page, court should seek to identify the earliest date of the underlying agreement and not. Sorry, forgive me, I've lost my way. Yes, settlements fall within subsection 10.4. 20.3, in cases falling under 10.3, time runs from the judgment or award of ascertained quantum, not an earlier date. So too under 10.4, there must be agreement as to the amount of money, not related to liability at Aer Lingus. 20.5, agreement must be identified as agreement for payment of the actual damage caused. 20.6, while section 10.4 talks about payment, such term includes both monetary payment and payments in kind. Accordingly, an agreement for remedial works is for the purpose of subsection 4, an agreement for the payment of compensation. The outcome of this case is set out at 26 to 28, and there's a discussion of the limitation defence in the alternative towards the end of that judgment. But this is a good case in the sense of drawing together those threads, and also the judge finding himself in agreement with the determination of His Honour Judge Havery. Now, turning back to Section 10, subsection 4, there may or may not be a gap in subsection 10.4 in relation to the fact that there are two stems referred to in subsection 4, makes or agrees to make. There is only one rose, which is the relevant date is the date of agreement. But that, my lords, my ladies, and my lord, can hardly affect the substantive position under section 1.1 of the Contribution Act, particularly in circumstances where subsection 1.2 also has made the payment as well as ordered or agreed to make the payment. So may I now turn to the grounds of appeal? I hope to be able to run through those quickly. So the grounds are in the core bundle of papers, divided in two.
We need to turn up your skeleton argument for this.
That may be useful, yes. So in the grounds, we're looking at core divided to page 33. So the first ground, those grounds set out at 5, 3, A, B and C, and 5.4 and 5.5. So those are the Contribution Act grounds. The first ground advanced is that the cause of action in respect of the contribution has not yet accrued. That's not right. 3 reasons. First, BDW is entitled to claim contribution when it can plead the 3 ingredients. We've pleaded that, and we're entitled to claim. Whether we are entitled to contribution is a matter for trial. In its skeleton, URS says that its argument in this respect is buttressed by the Limitation Act. That's not correct. There are 3 points. Point 1 is the same as before. We're entitled to claim it. Point 2, as we've said, the Limitation Act does not cut down the right granted by the Contribution Act. That's the case of Baker and Davis, which we've looked at. It is of interest to observe that the exact same point was run in relation to the 1935 Act and the 1963 Limitation Act. You can see that from STOT, which is D3. And Lord Denning, Master of the Rolls, was just as unimpressed with the argument as His Honour Judge Havery was. At the top of page 286, the judge was influenced by the wording of sections 4.2 A and B of the Limitation Act. That's at the top of page 286. Next paragraph B, I do not myself think that the later Act of 1963 should be allowed to cut down the substantive right given by the Act of 1935, the latter being the Contribution Act. Well, it was the Married Women's and Tortfeasors Act. Our task is to find out the meaning of the word liable, where it's used in the Act of 1935. And to similar effect, at 289, Lord Justice Salmon, as he then was, subparagraph B in the margin, in any event, the Limitation Act 1963 cannot, to my mind, cut down, nor does it purport to cut down, the powers conferred by the Act of 1935. And then the third point about the Limitation Act buttressing is, of course, that the Contribution Act itself refers to the meaning of payment. So ground 3B, no claim had been intimated, and therefore there's no entitlement to a claim of contribution. There are a number of points here, I can deal with it very quickly. The Act doesn't say that A needs to have intimated a claim. We looked at the quotation from Lord Bingham in Royal Brompton. The case itself is at D8 and it's paragraph 6. Lord Bingham identified the ingredients for a claim and contribution. He didn't say that A must have made or intimated a claim. It might be typical, but it is not necessary that A should make or intimate a claim. If the claim for contribution is deficient of one of its ingredients, then it will fail. Subsection 1.6, liability means which could be established in an action. That section, which is in the business of clarifying the meaning of liable, doesn't say, oh, and as well, by the way, to be liable, there must have been intimated a claim against you. Same point on subsection 6.1, 1.6 and 6.1. URS's construction results in an outcome where the proactive party who gets on and rectifies defects without waiting for a claim has no claim in contribution, whereas the one who does nothing, sits on his hands until a claim is made, does have a claim in contribution. Respectfully, we say that is a regressive and uncommercial outcome, stalling rather than encouraging quick responsive action. The damage is usually obvious. Here, in this case, there are structural defects in the developments. Final 2 points in this section. Nor can the true nature of the damage, whether it qualifies under the Act, be in any way determined or determinable by the manner in which A either intimates or makes a claim. What if, for example, the intimation or claim was inept? And finally, intimated in and of itself is grossly uncertain. What on earth does it mean? The next ground is 5.3c. BDW was not seeking to recover a contribution from URS in respect of liability to third parties established against BDW by a judgment or award, nor was it seeking to recover contribution from URS in respect of a bona fide settlement. Yes, we do not seek to recover a contribution in respect of liability under judgment or award. There is no judgment or award. It's right that we're not seeking to recover contribution in respect of a settlement. There isn't one. Even so, we're entitled to bring a claim for contribution. There's no need for payment to have been made to claim contribution. It happens all the time in the same action. Not only that, B is denying liability when he makes his claim and contribution. The scenario of payment without settlement is raised by the Act, and in any event, BDW has made payments in kind on the authority of Baker and Davis. And then finally, and most most obviously perhaps, it would be very surprising in relation to the hand-up if the first 5 of those examples were situations in which contribution could be recovered, but merely by reason of the absence of a settlement. In the 6th example, it cannot be. And nor is there any difficulty about the payment in kind to which the contribution will attach. It is simply the monies expended in terms of evacuation, propping and remedial works. Ground 4, 5, subparagraph 4, claim for contribution was not properly particularised, and that it didn't contain the properly particularised elements of BDW's cause of action. Well, respectfully, it did. We pleaded the 3 ingredients. And BDW's claim for a contribution relied upon an unjustified extension of Section 135 Building Safety Act, BDW having accepted that prior to the coming into force of the BSA, Section 1.2 would have meant that BDW had no such claim. Now, those points are amplified by URS at its skeleton at paragraphs 57, D, F and G, so far as we understand it.
Do you want us to turn to that?
Yes, please, probably useful. So, first of all, D, which is on page 30. Section 1.2 provides that whether B was liable must be judged at the point in time immediately before the payment. And then F, Section 1.2 provides that the question of B's liability must be judged at 2020 when the payments were made, not by the reference to the position after the BSA claim in force. That's the burden of it. As at 2020, no claims had been intimated, and if they had, they would have been time barred. And then the retrospective provisions of Section 135 cannot take effect in ongoing proceedings, and that's also what's said at G. So there are 4 points being made here. First of all, B's liability to A must be judged in 2020, not 2022, when the BSA is in force.
Hang on. B's liability to A, say that again?
These are the points made against B.
Yeah, I understand that.
B's liability to A must be judged at 2020, not 2022, when BSA in force. Second point, at 2020, no claim implemented.
Mm-hmm.
3, any claim in 2020 would be time barred. 4, Section 135 doesn't apply to current proceedings. Let me now answer those points.
Well, the 4th point, presumably, is covered by your submissions yesterday, whether right or wrong. You dealt with that, haven't you?
Yeah.
I don't think we need to go through all that again.
No,
Have
all right.
it.
So the first point's incorrect. The question of when liability is examined is at trial. The BSA will be in force at trial, and so it will apply. Second point, no claim intimated, irrelevant, not necessary. Third point, it's formulated as a time bar, but what's being driven at is Section 1.2. I've already explained that we agree that had the BSA not come into force, we wouldn't have been entitled to bring a claim in contribution. And importantly, at trial, leaving aside the submissions on the 4th point about Section 135 applying retrospectively and so on, at trial, when the question of liability is being determined, my client won't need to rely upon the retrospective nature, the retrospective effect of the Act, because at the time of trial, the Act is in force. So unless there are any questions, that concludes my submissions in relation to the Contribution Act.
Thank you very much.
Thank you. Now, we've dealt with the DPA amendments, we've dealt with the Contribution Act amendments. The court will recall that there are amendments made to the existing case, the negligence amendments. The learned friend didn't address you orally in relation to the negligence amendments. And unless I've made some mistake in interpreting her submissions, I propose to follow suit. That then leaves strikeout. Bit of a structure to be built. The court only needs to consider strikeout in circumstances where it has upheld the appeal from Mr. Justice Fraser on the preliminary issues, and either, number one, it agrees with the backdating argument of URS, namely, this court's order would in effect be backdated to the date of Mr. Justice Fraser's order, and it dismisses my client's objection that, which is, hang on, you can't just ignore the fact that the BSA has been enacted while this case has been going on, and that we've made an amendments application which was successful in relation to two different causes of action in addition. It needs to agree with that as well, and it needs to agree with URS's argument that we couldn't simply issue fresh proceedings here and now under the DPA and Contribution Act. So you have to uphold Justice Fraser and agree with all of those points, or you upheld both appeals from Mr. Williamson and you've determined that those claims are in effect knocked out. Now, just dealing with backdating, we've dealt with that in our skeleton.
You have.
56, 1 and 2. And as for fresh proceedings, well, we could simply issue fresh proceedings. There couldn't be any objection. Now, there's one remaining point on that. Sorry, two remaining points on that. One relates to the correct construction of 1356, but it's a different point. So if we can take up the Act. At 135 subparagraph 6. Nothing in this section applies in relation to a claim which, before this section came into force, was settled by agreement between the parties or finally determined by a court of arbitration. Now, the way the learned friend's submission works is she says, well, if I can be backdated and if all of the other obstacles are overcome, I can have the claim struck out, and that will mean it's been finally determined. That's how the argument goes. But respectfully, that's to misunderstand what subsection 6 is aiming at. Subsection 6 is in a wider subsection dealing with claims under the Defective Premises Act. It's extending the limitation period for claims under the Defective Premises Act. All that will have previously been determined is by clients claiming negligence. We say that this clause is not intended to bite on an action previously brought under a cause of action that isn't a defective. I haven't put that very well. What I mean to say is this: it only applies if you've previously brought a claim under the Defective Premises Act and that's been finally determined or settled. So even if all of the other hurdles were overcome, and Maloney Friend was right about all of those, this section doesn't prevent me issuing fresh proceedings under the Defective Premises Act or in contribution. And this is the very last point of all. Yesterday, and this was a new point, Maloney Friend took you to the claim form and said, aha, look, they put the Defective Premises Act in there and they put the Contribution Act in there. That's true, but we didn't plead claims in the Defective Premises Act or in contribution. As the court will be aware, Chandra and Brook North, decision of Mr. Justice Jackson, as he then was, makes clear that what you don't pursue in your particulars of claim, even though it may have been in your claim form, you can't use the claim form as a launch pad for amendments later on. You've nailed your colours to the mast is the phrase that he used by your particulars of claim. So that Maloney Friend can't do it that way and say, off go your claims in the Defective Premises Act and contribution. Okay, well, forgive me.
But they're deemed to be abandoned.
Yes, which is why we made application to amend to bring them back.
Just
To
give me
make
the name
it
of
for
the
the first
case again.
time. I'm sorry, Lord.
Just give me the name of the case again.
Chandra and Brook North. It's the case where claimants try and get round their limitation problems later on.
Yeah.
By pointing out, oh, look, it was in the claim.
It was in the claim form, yeah.
Sorry for galloping. Sorry for taking you to so many complex areas of the Contribution Act. Unless there are any questions, we invite the court to dismiss the appeals, and those are my submissions.
Thank you very much
Thank you.
indeed. Yes, Mr. Parkin, anything in reply?
A few matters, my lady. I'm probably going to start with the Contribution Act because that's fresh in everyone's mind.
Certainly.
Certainly from my perspective, if I put it down, I shall forget after lunch what I'd intended to say to your
After
lordship
lunch?
and the court.
Sorry, I'd anticipated your reply would not go into the afternoon.
It will, I'm afraid to say, go into the afternoon because there are a number of matters. I'm going to try and go as quickly as I can, but there are a number of matters on which I wish to address the court, in particular in response to some of the questions raised by Lord Justice Coulson.
Well, we'll see how we go. I am quite firm about what constitutes a reply and what is a second bite of the cherry.
I'm absolutely, completely understand that, my lady, and I'm going to do my best. But some of this is not second bite of the cherry stuff. In fact, all of it is not second bite of the cherry stuff in my respectful submission. I'm sure if your ladyship thinks it's second bite, she won't hesitate to say it as much. Starting with the Contribution Act. In my respectful submission, the beginning and the end of the Contribution Act can be found by considering the judgment of Mr. Justice Leggett, as he then was in Kazakhstan. In particular, paragraph 62 of that judgment sets out the argument which my learned friend now runs, which is namely that the cause of action in contribution is governed by clause 1.1 of the Contribution Act. Mr. Justice Leggett dismissed that argument and went on, as you will recall, to define or to consider when a cause of action in contribution might occur, and indeed he, in that case, held for the freezing injunction that the cause of action occurred by the issuing of the Part 20 claim form. If Mr. Hargreaves' analysis had been right, all he would have needed to say in that case was that the cause of action accrued as soon as the right to contribution occurred in those proceedings, and that's not what he said. So that, in my respectful submission, is the guiding principle in terms of what Mr. Justice Leggett says in the Kazakhstan case in terms of how the Contribution Act works. The next point made by Mr. Hargreaves was that the nature of the damage claimed by A cannot be determinative in a contribution claim. Now, in my respectful submission, that is a surprising state of affairs, not least because one sees from the case of Co-op and Taylor-Young that the nature of the damage claimed by A was the deciding factor in that case. by way of brief summary of the facts of that case, that was a claim which arose as a result of a fire in a building. The fire, the costs of rectifying the damage caused by the fire were covered by joint names insurance taken out under the building contract. And the joint names insurance was taken out between the employer and the building contractor. The employer sued the architect for damages, constituting the costs, the remedial costs associated with the fire. The architect sought to make a contribution from the main contractor. The court, the House of Lords, well, in fact, all three courts, Ms. Honourable Judge Wilcox, the Court of Appeal and the House of Lords, all held that there could be no contribution in that case because the main contractor could never be liable to the employer because of the terms of the joint names insurance under the building contract. Without the claim up the line from A, in that case the employer, the architect could have framed the claim against the main contractor in any way he or she chose to do. It is the claim from the up the line party A in Mr. Hargreaves' diagram, which is the issue which decides the contribution, who is liable for what and in what amounts. And one can see that from all of the cases that Mr. Hargreaves took you through this morning, even the one that he said was on all fours with this case, which was the judgment of His Honour Judge Havery. He started off by saying to you that the claimant had settled with the building owner. In this case, there is no such settlement. So that is briefly contribution, my lady, and you obviously have my submissions on that first time round. Just in answer to the question raised, I think twice by Lady Justice Asplin, I think both to me and to Mr. Hargreaves, about what is it that makes professional negligence cases involving buildings different. Might I invite your ladyship to look at what Lord Lloyd says in Cargill, which is, if I can just give you the reference, A2 636. I can't remember the letter offhand, but it's in the middle somewhere. But effectively what he says is the difference is that these are not pure economic loss claims as traditionally understood. They are economic loss claims which concern the physical damage to the building. If one starts from there and works forward to the next question, when does that damage occur? There are a number of possible scenarios that have been ventilated, and just to pick up and take up the invitation from Lord Justice Coulson on the doomed from the start matter, if I may, my lady, just so that the court knows, that was expressly disavowed by Mr. Hargreaves when he opened his case in front of Mr. Justice Fraser. When we were both asked to put in submissions on the question, Mr. Hargreaves said he put his case on the New Islington basis, but just as he said to Lord Justice Coulson, well, if the court determines it's doomed from the start, so be it. That is the submission that's made to this court as well. And in my respectful submission, the lack of enthusiasm with which Mr. Hargreaves embraces doom from the start is well placed, if I might put it in those terms, because the doom from the start argument has itself been doomed from the start, and the court can see that if it looks at the case of Ketman, which I don't think we were taken to, which is tab, and if I may, just very quickly, my lady, it's tab 7 of, oh, I'm so sorry, my lady, the core bundle, first core bundle of authorities.
Page 205.
I'm obliged. G to H.
I think we must have been to it because I have it marked up. Thank you.
And we say that this case is clearly not on all fours with Kettman, because Kettman was about defective foundations. But the point about Kettman and the point about
Kettman was a case about physical damage, so obviously it doesn't apply.
No, my lord, but the point is that what the House of Lords was saying in Kettman was that where physical damage is at some stage going to occur, it cannot be a doomed from the start analysis. And what we say is that clearly, in this case, the need for the remedial works is because of a concern that physical damage might occur. If no physical damage were in the offing, so to speak, there would be no need for the remedial works in the first place. So we say this is not doomed from the start, and we would caution the court against resurrecting a doctrine which I think has historically been thought to have died a death, if I may put it in those terms. So that's doomed from the start. What then does English law say about damage? The tension has arisen because of the very fact that, as Lord Lloyd explains in Invercargill, building cases are about physical damage to a building, albeit that the law calls it economic loss. And the tension has been because initially the House of Lords called it physical damage. See Annes, see Pirelli. That error was corrected in Murphy and matters have been recharacterised as economic loss. How then does that affect when a cause of action for economic loss accrues? There are effectively two answers to that question. Answer one is it accrues upon the adoption of the construction, the incorporation of the design into the construction of the building. That is an answer which was of attraction to Mr. Justice Dyson in New Islington. However, it has been not the approach which every appellate court who has considered the matter has found. And in particular, Lord Keith in Murphy, Lord Lloyd in Invercargill, Lord Nichols in Bank of East Asia, and Lord Justice Tuckey in Abbott all say that when one considers economic loss to a building, the point at which the cause of action accrues is when effectively the value of the building is affected, and the value of the building can only be affected when the damage is known about. And Lord Nichols, as you will recall from what Lord Justice Coulson described as putting the matter, certainly nailing his colours to the mast, said in terms, this puts building cases in a different set sets them apart from the financial cases. And so we say there is that theme going through all of the cases, and it is a theme to be applied here. There were a section in Mr. Hargreaves' submissions about this time yesterday where he took you through the Newton Abbott cases, and I think 3 or 4 cases which followed on from Newton Abbott, including Director of War Service Zones and Harris, with the exception of one of those cases, GlobalNet, which I'll come back to in a moment. All of those cases were cases which concerned the quantification of damages for breach of contract. That is an important distinction, my lady, and the reason for that is, of course, that the law of tort starts from a different place. It starts from the perspective that damage is the key element of the tort. And the question for the court is, what is the nature of the damage against which a professional owes a duty, assumes a risk to protect against? Quantification of that damage is an entirely separate matter. appreciating the difference between damage and damages. As Mr. Justice Stuart Smith said in Co-op and Burse, the risk that a designer is to guard against is twofold. It is the risk to causing damage to the proprietary interest in the building, the value of the asset. Now, of course, obviously in Burse, as Mr. Hargreaves accepted this morning, Burse did not have a proprietary interest in the building, so that, in a sense, was irrelevant from a Burse perspective. But from our perspective, it's extremely relevant because BDW did initially have a proprietary interest, and in some cases continued to do so for a significant period of time. So that's limb 1, the risk that your scope of duty extends to protecting against the risk of damage to proprietary interest. Limb 2, your scope of duty extends to protecting against claims made against you. And in Burse, a claim had been made against Burse. So the constituents of the cause of action were there. Mr. Justice Stuart Smith was considering is when that cause of action accrued. Here we say the constituents are missing because no claims have been made against BDW. Now the suggestion, my lady, has been, well, essentially BDW has acted such that effectively they are, no further claims could now emerge from the woodwork. That is not the case at all. It would be entirely possible for the residents to bring claims under the Defective Premises Act or through seeking a remediation contribution order under the Building Safety Act for two sorts of matters. Firstly, if they considered that the work which BDW had done was not sufficient to rectify the defects. And you'll note from the particulars of claim, we don't need to go there, but you will note that there are design defects which have been identified, but which have not been rectified. Point 1. Point 2, they could still bring a claim for diminution in the value of their properties. A blight claim. I'm not suggesting that those will inevitably happen. What I'm saying is that it is not necessarily the case that BDW has stepped in and corrected everything such that no further claims will eventuate.
And the relevance of that?
Why does that matter?
It is effectively, the submission being made is, you don't need to worry. We've incurred a lot, just because a claim hasn't been made, you don't need to worry because we've mopped up the mess, effectively. And I'm saying it's not necessarily the case that they've mopped up the mess. So that the co-op and burst situation might happen later on.
I'm not sure I understand how that helps you.
It's this idea that one doesn't need a claim up in order to bring these proceedings. A claim is not necessary because somehow what they have done is obliterated the need for a claim.
But if there are
That's
further
not
claims,
how I understood him to be putting it.
I think it is how he's putting it, my lady.
Only in part. He's shaking his head, so...
Well, I'll move on. I'll move on. Effectively, the rival contentions before the court on the scope of duty
Yes.
are paragraph 16 of our skeleton argument.
Would you like us to turn that up?
I'm giving your ladyship's indication. I'm just going to, if I just give you some references, then.
Anything you need to say in reply, we're happy to hear. I was just giving you my standard warning about re-arguing cases in reply.
Duly noted. Paragraph 16. It is probably sensible, my lady, if you would be so good as to turn it up, that would be of assistance, and you will find it at page 8.
Thank you, I have it.
We set out in sections A and B, so paragraphs A and B, words that will have a ring of familiarity to them, and the reason for that, my lady, is that they are based expressly on what Mr. Justice Stuart Smith says is the scope of a duty of a designer in Burst. And that's at paragraphs 27 and 28 of his judgment, which have been taken to a number of times now. So that's what it is that URS says. BDW's case is much wider, and that's put at paragraphs 48 and 49 of the skeleton, which in essence adopts the judge's conclusion at paragraph 49 of his judgment. And that is in essence that if you build a building, you are liable for defects in it. Now, in our respectful submission, that is way too wide, and the reason for that is this. Samco and NICredit are authority for the proposition that, effectively, one does not assume as a professional all the risks inherent in the providing of the advice, or in this case, the design.
Absolutely, you just accept the risks of your design.
And that is why...
Which is what this case is about.
And that is why Mr. Justice Stuart Smith limited the scope of duty in the way that he did in paragraph 27 and 28 of his judgment. And we would respectfully urge the court to adopt the narrower formulation. And the reason that that matters is when one comes to the accrual of the cause of action, of which, as the bench is aware, there are 3 types. The primary case, which concerns effectively a damage to the proprietary interest in the property. The secondary case, which is Mr. Hargreaves' package of rights case. And the tertiary case, which, as we saw when we looked at the pleadings, is the reputational loss case. And I do put it in those terms. And the reason that I put it in those terms is because that is what the pleading says. The question asked was, what is the nature of the damage suffered at the point in time that you incurred the remedial costs? And the answer given is, effectively, we incurred the costs in order to protect the reputation. I'm using that as a shorthand. You've seen the paragraph. That is, in my respectful submission, a case that is not open to my learned friend, because Mr. Justice Fraser found on reputational loss. Now, the reason that he didn't go on to strike out everything in terms of the loss and damage section of the pleading is because he never got round to considering the tertiary formulation of accrual of the cause of action. His view was that the cause of action accrued at the point in time that the buildings were built. So he was viewing things through a very different lens. Moving on to the DPA, my lady. It was suggested, we will recall the discussion between me and the bench on Wednesday, Tuesday, about about limitation of liability clauses and section 6(3) of the Limitation Act. And it was said against me yesterday. Well, so two things were said against me. Firstly, it was said that the Defective Premises Act is concerned with cases so egregious that it would in fact be right to not allow a professional to rely on its limitation of liability clauses in cases like that. Now, the suggestion being that the bar set by the DPA was somehow a very, very significant bar in terms of the nature of the defects, which would allow the cause of action to be run under the DPA. I just want to show you that that's not exactly the case, and I can do that, please, very quickly by taking the court to Rendlesham, which is, I'm afraid to say, in section, it's C, thank you, my lord. C4. I'm obliged. And we can start, this is a claim brought by the owners of, or the residents of a rather unfortunate block of flats in Leeds, I think. I say unfortunate because, as you will see when you turn on to page 3668, at paragraph 13, Mr. Justice Edward Stewart lists the appendices which concern all of the defects which were said to give rise to a cause of action under the Defective Premises Act. Now, you'll be grateful to learn that I'm not taking you through all of those, but let's just focus on M, shower trays. And for those purposes, if you could turn on to 3691.
Sorry, turn up
page 3691, paragraph 268, my lord.
Thank you.
Where one sees that the judge held that the defects in the shower trays were defects which fell within section 1(1) of the Defective Premises Act.
Well, I haven't read all of this, but just quickly glancing at it, except for the ones that had a bathroom as well. So it was unfit for habitation because there was no way of carrying out one's ablutions.
Absolutely, but the point is, my lady, I'm not for one moment suggesting that for the people who inhabited these buildings, these were not a serious issue.
But I mean, we are getting into a complicated world here, aren't we? Because the Act says fit for habitation.
Absolutely. And
so, and I take your point completely. You say it's not that high a bar after all. There's actually a duff shower tray will do. But for my part, I start wanting to think about what about the building regulations and what about health and safety and what are the requirements that, you know, is a house fit for habitation for the purposes of foreclosure and all the rest of it if you can't have a bath or a shower. So
no.
I just kind of feel that this is a bit of potentially a bit of a rabbit hole.
I'm not intending to go down a rabbit hole. What I'm trying to say to
I mean, if you need to do, but it seems to me that this...
I'm not. What I'm saying is that the suggestion that somehow claims under the submission goes as follows. It's entirely reasonable that professionals should not be held to limitation of liability clauses because claims in relation to DPA are reserved for the most serious of matters. And what I'm trying to submit to
you want
the court,
to dumb down fit for
effectively
habitation.
is to say it isn't just the most serious of matters, it covers a whole range of matters.
Understood.
Which mean that the submission that somehow it's right to put to one side a limitation of liability clause because of the seriousness is somehow, it needs to be seen within the context of the nature of the claims that can be made. So that's
So you
point,
say it puts it too high.
it does put it too high. That's point one. Point two is this. It was also said against me, well, if the residents sued the engineers, then the engineers wouldn't be able to rely on the benefit of their limitation of liability clause. And true that is, because the limitation of liability clause is against the main contractor. But what the engineer could do at that point in time is it could join the main contractor for a contribution under the Contribution Act and invite the court to have regard to the limitation of liability clause entered into for the purposes of assessing the contributions to be made.
Do you mean the main contractor, or in this case, do you mean the developer?
Yes. Anybody else who happens, yes, I do. I mean, the person...
So you'd be joining the developer for a contribution
Absolutely.
to the consequences of your duff design.
On the basis that as between us and the developer, we had agreed a limitation of liability. And that the court should give effect to the limitation of liability clauses between us. Now, that may be a good submission or it may be a bad submission, but it is a route open to me. On the facts of this case, that remedy would be removed. I would not be entitled, obviously, to a contribution from BDW because they are suing. I wouldn't even be entitled to assert a contributory negligence defence because this is a statutory claim. And I would not be entitled to rely on my limitation of liability clause. Now, the reason that I'm making all of these submissions, as the bench knows, is because I say that Section 6.3 is a powerful indicator that the Defective Premises Act was an act designed to give purchasers of new dwelling houses remedies. And my Lady Justice Asplin may remember, perhaps she rather regrets it now, making the reference to Hansard. But I would invite the court to look at Hansard because the social purpose of the legislation is...
Have you agreed this between you?
It's in the bundle, my lady.
So you've agreed to us. Very well.
If you recall, I, when saying whether there was anything in Hansard, said, but I'm not saying necessarily whether it's admissible and the purpose of the exercise.
And then, yes, you may remember the way it worked was I started with the Law Commission report.
And you used it as a lead into the commission.
And Lady Justice Asplin was unimpressed by my delving into the Law Commission report and said that she might say if there were anything in Hansard, then she might take a different view, at which point I said, in fact, Hansard does refer to the Law Commission report. And what Hansard says in terms is this is a piece of social engineering legislation designed to give effect to the Law Commission, designed to confer rights on purchasers of new dwellings and those who acquire the new dwellings from them subsequently.
But the new point you're making in reply?
Effectively, what I'm saying to you, my lady, is that it's again reiterating and inviting your ladyship in her own time to go away and look at that point in Hansard.
In order to reinforce your submission that 1.1 doesn't apply to development.
Absolutely. And finally, there was this is on the DPA, there was a suggestion from Lord Justice Coulson that the 1972 Act was passed in circumstances in terms of the housing market very different to those which prevail today. He said he would find it very odd now if somebody went and commissioned a builder to build a new house, and most of us bought these from developers these days. In my respectful submission, the task for the court is to construe the 1972 Act by reference to the mischief that the 1972 Act was intended to address. And it is notable that in terms of the coming into force of the Building Safety Act, that is the route which Parliament chose.
Absolutely. And so the exclusion, for example, of limitation provisions or things that seek to qualify liability, they must have seen that and said, no, that's what we want to do.
In relation to owners of property?
Well, that's your
Yes.
second submission, but just looking at it, that's quite a powerful point, isn't it? This is real consumer legislation. Clever clauses go.
For consumers, yes, my lord. And indeed, one can see that the DPA, or the extension of the limitation under the period under the DPA, is just one of a whole raft of protections which the BSA gives to the people who live in the flats. The others being, in summary, the fact that the leaseholder is no longer entitled to levy service charges by reference to carrying out remedial works, that's gone, and that those who live in the blocks can now apply for the leaseholder or the freeholder to carry out the remedial works under a remediation contribution order. So, as I say, the BSA, there's a whole raft of things for the protection of the people living in the flats. So effectively, DPA. Retrospectivity. There's a lot of reliance yesterday on a case called Queen and Kadir, and I'm afraid I didn't deal with that in my submissions, partly because I'm a bit nervous about how many penalty points I'm going to incur by handing up an authority, a new... It's the House of Lords decision in Kadir, which was referred to.
Thank you.
Can I suggest it slots in behind Kadir in the core bundles, maybe?
Certainly.
Sorry, behind which in the core bundle?
Thank you.
Kadir.
Where is it?
Kadir.
Where's that?
Thank you.
Which number's that?
I think you've given us too many copies.
Oh, I'm so
You've
sorry.
given us all your copies. I think.
Yeah,
You've
I've
given
got
us
another one.
I've got 3 copies.
I've got 2, so I shall give you one back.
May I give you this?
It's my lord, Kadir in the core bundle is in volume 1, tab 15.
Thank you very much.
I would like to spend a little bit of time on Kadir because it's important to understand what Kadir does and does not decide, in my respectful submission. And it's behind, let's start with the Court of Appeal decision. And if we could start first, please, at paragraph 24. You can see that counsel for the government in paragraph 24 was not initially seeking to rely on section 67 of the 2002 Nationality, Immigration and Asylum Act. And what happened was, it's one of those awful moments where the court says, but counsel, you do seem to have forgotten there's a new piece of legislation. And so effectively submissions are made, and as you will see, she eventually accepted that, having thought about it, the court couldn't disregard it, and so she must place some reliance on it. And so, effectively, the argument proceeds. The judgment of Lord Justice Mance is the judgment which contains the most comprehensive consideration of retrospectivity. And I'd like to start at paragraph 85. And just before I do so, you will recall that this is the Act which has the shall be treated as always having effect provision. Lord Justice Mance says this: in an appropriate context, any United Kingdom legislation similar to that under scrutiny in this last case, that's the Ireland Government of Malaysia, would have now to be viewed in the light of Article 6 of the European Convention on Human Rights, Section 3 of the Human Rights Act 1988, and the jurisprudence of the European Court of Human Rights. You may remember I referred to that yesterday when we were looking at the Wilson and First County case. Article 6 being the one which confers the right to a fair trial, and which, as I indicated, has been interpreted by the European Court as not allowing the rules of the game to change halfway through. Then Lord Justice Mance sets out two decisions of the European Court which say as much, very briefly. And then at 86 he says this: that a powerful argument could in an appropriate context be made based on these and other authorities is confirmed by the judgment of Lord Roger of Elfrey LP in Anderson and Scottish Ministers. However, the present is not an appropriate context. The European Court has, by a majority of 15 to 2, confirmed that litigation concerning immigration control does not concern the determination of a civil right within the meaning of Article 6.1, despite acknowledging the major repercussions on an applicant's private and family life or on his prospects of employment that such litigation may have. The European Convention on Human Rights can, it seems to me, be put on one side. That is not the case here, where Article 6 is engaged, and as I said to you during my submissions on this point yesterday, it is a principle of construction which this court is required to adopt when construing Section 135 of the Building Safety Act. So you are required to construe Section 135 to give effect to Article 6. That was not an option which was open to the Court of Appeal in Secretary of State for the Home Department and Kadir. And as a result, the court found as it did. Turning very, so that was 2003. After the Court of Appeal in 2003, the Supreme Court handed down, well, you will have seen the Supreme Court decision in Wilson and First County. I took that to you yesterday, in which a comprehensive review of the principles about construing retrospective legislation so that pending actions are not affected unless clear contrary words are to be found. We looked at that yesterday. I think that's 2004 from recollection. 2006, Kadir reaches the House of Lords, and that's the case that I've just handed up to your Lord, to the bench. As my learned friend explained yesterday, the House of Lords started by saying that everyone before them had got it wrong and that it was possible to construe the earlier legislation to do exactly what the minister wanted to do. And so, effectively, they didn't need to worry about the effect of the 2002 Act, which had itself thought perhaps been passed up yesterday. I want to just refer to, there's only one speech given, that's Lord Brown, and the final paragraph at paragraph 36 is the important one. From all this, it follows that, in my opinion, Section 67 was an unnecessary enactment. What it provided for had, in any event, always been the law. It therefore becomes necessary to decide whether or not the Court of Appeal was right to regard Section 67 as effective to deprive the appellant of the benefit of his victory at first instance. Since, moreover, such an exercise, besides being wholly academic, would be quite unreal because based on a false premise, I would propose that your lordships say no more about it than that this House is not to be taken to have endorsed the Court of Appeal's views upon any of the many issues underlying their decision on retrospectivity. So I put that before the court by way of completeness. We say Kadir is completely distinguishable because Kadir did not involve Article 6. This case does. Thank you. And turning back to the question that your ladyship, Lady Justice King, posed to Mr. Hargreaves at the end of yesterday, and we came back to today about whether an amendment is a repeal. Every repeal, in a sense, is an amendment. They are two sides of the same coin. The point is that before the coming into force of the Building Safety Act, there was a 6-year limitation period which was attached to the DPA claims. There is now, in this case, a 30-year limitation period. In other cases, a 15-year limitation period. We say that is an amendment, and that engages Section 16 of the Interpretation Act. And again, as I said to the court yesterday morning, whether one gets to it via the adoption of the common law construction against requiring express words in order to put to one side the presumption that retrospective legislation will apply to existing proceedings, or through an implied repeal, or through Article 6 of the European Convention, which the court is required to take account of. The effect is the same. Section 135 cannot be construed in such a way as to enable the claimants in this action to take the benefit of the Building Safety Act. Now, it's somehow suggested that the words were on the claim form and then they weren't followed through. And so in the light of Chandra and Brook North, those claims were somehow abandoned or thrown away. 2 points in relation to that. If they had been abandoned or thrown away, Mr. Hargreaves would have been required to make an amendment to his claim form to add them back in when he came to this court seeking permission to amend, because the claim form would not have been wide enough to encompass such claims. And in relation to the Contribution Act, as you will have seen from the pleadings, a claim was indeed, or reference to a claim for contribution was made. Mr. Hargreaves has been quite candid both in front of Deputy Judge Williamson and indeed before this court that prior to the coming into force of the BSA, he couldn't bring a contribution claim because of limitation. And so for those reasons, my lady, we do say that both the DPA claims, which would have failed for exactly the same reason, and the contribution claims were part of the existing proceedings. And one can see that because the only change made to the particulars of claim is what one might call the slightly formalistic change of adding in references to the existence of the duty and the breach. And there is another point on Section 135, particularly in relation to the Contribution Act, which is this. Section 135 makes no reference to the Contribution Act at all. As the court will see when it goes back to consider Wilson and First County, one of the first principles of construing retrospective legislation is the requirement to construe the retrospectivity absolutely no further than necessary. And it's for that reason that clear words are required. There are no such clear words in this Act which relate to the Contribution Act at all. And one can see the difficulty when one looks at Section 1.2 of the Contribution Act and considers it on the facts of this case. We were not liable when we made the payment. And we accept that, which is why we did not run the contribution claim first time round. We are now able to do so. And there's a slight tension again between Section 1356 of the Act, of the Building Safety Act, which talks about a settlement of a claim prior to the coming into force of the Act, prohibiting the bringing or the reliance on Section 1 through the extended reliance on Section 135, and the bringing of a contribution claim which is relying on a payment made before the Act came into force. So we say that essentially you can't have it both ways. And so for those reasons, my lady, we say, and maybe just finally picking up on a point made by Lord Justice Coulson, I think, well, I say, Lord Justice Coulson started this morning by saying not really a very short point of law in relation to the Section 135 point. The point about Section 135 is it acts like a limitation defence for somebody in my shoes, by which I mean that if these claims are made in existing proceedings, I am entitled to rely on Section 135 as a bar to the bringing of the claims. It is a procedural bar. And so it may or it may not be a short point, but it is nonetheless one which a court is required to grapple with in cases such as this, where reliance is sought to be placed on it in ongoing proceedings.
But that isn't right, is it? Because we know, I'm not saying this case, but those of us that do this work know that limitation often arises. It's very rarely taken first because of the complexities of doing it. So you have a procedural bar as a defendant, which, if you're right, means you have a complete limitation defence. But the complete limitation defence isn't worked out at the outset.
Well, with respect, my lord,
and of course, we can see that here, because although it's all about limitation, this case, that's not one of the preliminary issues.
When a party applies to the court seeking permission to amend to add a claim, a defendant is entitled to say that permission should be refused because the limitation period has expired.
Yeah.
And the court is required to determine that by way of effectively the hurdle that the court has, that the claimant has to overcome in order to be given permission to amend. And that's what this court did the first time this claim was before you.
Yeah.
The submission that we made to the judge was that Section 135 had a similar effect in these sorts of cases. It was a sort of a threshold defence, if I could put it like that.
Yes, well, I wondered about that, because taking that to a logical conclusion, you say it doesn't matter that it's not short. You say the court is required to deal with it, even if it's long, complicated, and has taken half the time of a 2.5-day case in the Court of Appeal.
Well, it hasn't quite taken half the time, my lord, but yes is the answer. I do say that the court is required to deal with it.
And you do say it doesn't matter that it's not short.
I do say it doesn't matter that it's not short, my lord. And in my respectful submission, it actually is quite a short point. It's the construction of a statute, and it's entirely the sort of thing that the court ought to be embarking on before deciding whether to give permission to amend. Can you just bear with me one moment? Bearing in mind the encouragement from the bench and only 5 minutes into the short adjournment.
Not at all, and you've covered a great deal of ground, and
I
we're very
galloped,
grateful.
I think.
No, well, it didn't feel like a gallop, it felt concise, which is different.
Well,
Yes.
ladies, my lord, I'm putting my hand up. Do forgive me. Could I crave 2 more minutes of the court's time? It's quite an important submission. I'm quite troubled by my learned friend's submissions in relation to convention rights. Let me explain why. If I can take the court, first of all, to section 1355 of the DSA. Now, this is
saving provision.
Yeah, 1355 directly on the point in relation to human rights matters, where an action is brought that, but for subsection 3, would have been barred by the Limitation Act, a court hearing the action must dismiss it in relation to any defendant if satisfied that it's necessary to do so to avoid a breach of that defendant's convention rights. Now, in the skeleton argument, which was served for the hearing before Mr. Adrian Williamson KC, which you will find in the supplementary bundle, volume 1, behind divider 23, and forgive me, I do invite you to turn it up.
Yes.
The court will find that at page 174 of the bundle, 175 of the bundle, and 176, detailed arguments were raised in relation to breach of convention rights. When the matter came on before Mr. Adrian Williamson of King's Counsel, those arguments were not pursued at the amendment stage. My learned friend accepting that those would involve complex questions of fact, which therefore needed to be determined at trial. She therefore no longer pursued that line of argument in connection with objecting to my application for permission to amend. That was all I wished to go.
May I just say two words in
two words, and then I'll bring the ping-pong match to an end.
He's absolutely right, he did. This is a different point, my lady. This is a point about the way in which one has to construe the legislation in relation to whether the retrospectivity extends to ongoing proceedings. And the point I'm making to the bench is there are 3 ways of getting there, but you have to have regard to your convention obligations. And I'm going to sit down.
Thank you very much. Well, Mayor, thank you all very much indeed. Not just to Ms. Parkin and Mr. Hargreaves, who have demonstrated their expertise in this complex and difficult area, considerable skill, for which and good humour, for which I'm very grateful. But actually, more particularly, if I look over both of your heads, to everyone behind you, your juniors, who I know I can still remember vaguely. What it felt like and how much hard work and how the amount of support that each of your leaders will have had in the preparation of this very complex case. So thank you. But also to those behind you, I'm looking further back now to all the people that have prepared this case, taken instructions from the lay clients, coped with it all, and put together the absolute excellent bundles, which of course have then required the agreement and the cooperation, which can be very difficult in these sort of cases. So may I thank all of you very much for the absolutely excellent way this case has both been prepared and presented to each of us. Unusually, I think we've actually behind the scenes, each of us have made specific comment about it. So thank you all. You won't be surprised that we're going to reserve our judgments. So in due course, and obviously it is in due course, but we are conscious that these are ongoing proceedings and this is an appeal from preliminary points, so we hope it won't be too long. You'll be sent the draft judgments. I know you're conscious of it, but might I re-emphasise for anyone who perhaps will be handling the drafts who aren't as familiar with the new embargo, that we taking that embargo now set out at the top of the drafts extremely seriously. A list must be prepared. I'm afraid it often falls to the instructing solicitors to persuade every director in the companies involved that it's not necessary for them to be able to read the draft judgments. They will all have their opportunity in due course. The draft is to deal with typographical, minor factual implicities. It's not an opportunity to re-argue. I hope you'll be then able to agree an order between you. We'll deal on paper with any consequential matters. So thank you all very much indeed.